Anna Merritt had spent 12 years doing work that does not appear on a resume in any useful way. She enlisted at 22, started as a military intelligence analyst, moved into translation work, and then into assignments in units whose names she is not permitted to say in public. She did 3 overseas rotations. She came home from each one quieter than she left, in the way that people get quiet when they have seen enough to understand that most of what gets said about war is either too much or not enough. She was 34 years old and she had never once regretted enlisting. That part is important because what came next had nothing to do with running away from the army. It had everything to do with running towards something else. The call came on a Tuesday in October. Her grandmother Eleanor Merritt had been diagnosed with stage 4 ovarian cancer. The doctor had used the word palliative. Anna filed her separation paperwork the same afternoon. Her commanding officer called her into his office the next morning and told her the timing was complicated. Anna told him it wasn't, not from where she was standing. He signed the paperwork 3 days later. 6 weeks after that, she was in Knoxville. Eleanor's condo sat on the top floor of a pre-war brick building in the 4th and Gill neighborhood a few blocks north of downtown. Original hardwood floors, dark and worn smooth in the paths people walk most. Tall windows that let in the afternoon light in a way that made a room feel older than it is. Bookshelves built into every wall that had a wall to spare, floor to ceiling. Packed without any system, Anna could ever identify paperback novels next to legal dictionaries, next to a 40-year-old joy of cooking with a broken spine. Anna had spent every summer of her childhood in that condo. She knew which floorboard creaked near the kitchen doorway and which window stuck in the humidity, and exactly how the light moved across the living room floor between 4 and 6 in the afternoon. She cooked broth and brought it to Eleanor in the chair by the window. Eleanor accepted it with a thank you that did not make a production of itself. She was not a woman who performed gratitude or performed anything else. She sat and watched the street below, the foot traffic, the neighbors walking dogs. The kids on bikes in the late afternoon, with a steadiness Anna recognized but could not have named precisely at the time. It was the calm of someone who has looked at something large and irreversible and decided without drama that acceptance is more honest than resistance. Eleanor had raised Anna. Not in the way grandparents sometimes help out on weekends. In the actual daily way: homework, meals, school pickups, the conversations that shape how a person understands the world. Anna's parents, Robert and Linda Merritt, had been present in the technical sense. They had careers and obligations and reasons that had seemed, when Anna was young, like explanations. She had told herself for years that busy was just the word for how some families ran. By the time she was sitting in that condo making broth, she had long since stopped telling herself that. There is a version of this story where Anna stayed in the army and sent cards. Where she called on weekends and visited at Christmas and told herself that was enough. She chose not to live that version. That choice, that specific deliberate choice, is what everything else in this story turns on. Eleanor died the following March on a morning when the windows were open and you could hear the street. Robert and Linda drove up from outside Knoxville the morning of the funeral. Dana came down from Nashville 3 hours on the interstate. They arrived within an hour of each other, and by the time all 3 were inside the condo, Anna had already understood something she had not quite let herself name before. It was not anything they said. It was the way they moved through the rooms. The way Robert paused in the doorway of the living room and looked at the built-in shelves, then at the windows, then at the ceiling height. In the slow sequence of someone taking an informal inventory. The way Linda asked twice which neighborhood this was exactly and whether the building had a homeowners association. The way Dana walked the perimeter of the kitchen and said almost to herself that the layout was actually better than she had remembered. They had come for the funeral. That part was true. But something else had come with them, and it moved through the rooms ahead of them like a draft from an open window. Eleanor had executed a formal notarized will 2 months before she died. Anna had not known it existed. The attorney handling the estate contacted her 4 days after the funeral, and Anna sat in his office on a Tuesday afternoon and learned that Eleanor had left the condo solely to her. The notarized statement accompanying the will was not long. Eleanor had not written it to be eloquent. She had written it to be clear Anna was present. The others were not. 7 words. The kind of sentence that does not leave room for interpretation. The will had not even cleared probate yet. The ink was barely dry on the death certificate. Some people do not wait long to show you who they are. 3 days after the funeral, Anna was still in the condo. She had taken on the work of sorting through Eleanor's things, not because anyone asked her to, but because it needed doing, and she was there. Dana had stayed too nominally to help, though her presence mostly consisted of sitting at the kitchen table with her phone and occasionally asking where things went. Anna was in Eleanor's bedroom working through a shelf of books and deciding what to keep and what to donate when her phone rang. It was Robert. His voice was level and unhurried, the voice of a man who had made a decision before picking up the phone and was now simply relaying it. He told her they were going to contest the will. Grounds: lack of testamentary capacity. Eleanor's condition at the time of signing, he said, did not allow for sound legal judgment. Anna was trained in this area, she would understand the basis. He said it the way someone says a thing they have already discussed with an attorney, already agreed to, already set in motion. Anna was holding a box of Eleanor's books when he started talking. By the time he finished, she had set the box down on the floor and was standing very still in the middle of a room that still smelled faintly of Eleanor's hand lotion. She came out into the hallway. Dana was at the mirror near the front door adjusting her hair. She had been standing in that spot for at least 10 minutes. When Anna appeared, Dana looked at her in the reflection, not startled, not caught, just looked. Then she smiled. It was a thin smile, precise, the kind that does not involve the eyes. Anna had seen that smile her entire life and had spent years not knowing what it meant. Standing in that hallway 3 days after burying the woman who had raised her, she finally did. That night after Dana had gone to bed, Anna sat at Eleanor's kitchen table and called Natalie Rhodes. Natalie picked up on the second ring. They had gone through intelligence training together over a decade earlier, been assigned to different units afterward, and stayed close in the way that people stay close when they have shared something that does not translate well to civilian conversation. Natalie had separated 4 years before Anna did and was now in-house counsel at a firm in Knoxville. Anna told her everything start to finish without editorializing. Natalie listened without interrupting, which was one of the things Anna had always respected about her. When Anna finished, Natalie was quiet for exactly 2 seconds. Then she said, "Do not leave that condo. Not for any reason, not under any pressure, not even if it feels easier to go. You are in possession and that matters. Second, pull every medical record you can get your hands on and start documenting Eleanor's condition in writing, specific dates, specific observations, everything. Third, you need a probate litigator, not a general practice attorney." She had someone in mind. Victor Hale, 52 years old, former Knox County Chancery Court judge, 28 years in estate litigation since leaving the bench. Call him in the morning. Anna called him at 8 the next day. He saw her at 9:30. Victor Hale's office was on the second floor of a building on Gay Street. Tidy and without decoration except for 2 shelves of case reporters and a single framed photograph of the Tennessee River that Anna never saw him look at. He was compact and deliberate, a man who created the impression of stillness even when he was moving. He listened to Anna's account the way people listen when they are genuinely tracking every word and will not need to be told anything twice. When she finished, he set down his pen. He told her the opposing side would almost certainly argue testamentary incapacity, the standard challenge in a contested will case, built on a narrative that Eleanor's pain management and physical decline had compromised her judgment at the time of signing. It was a common argument, and not a weak one when the facts were thin. Then he told her they might also try to complicate Anna's own credibility. Service history, he said carefully. Post-traumatic stress instability, a suggestion that Eleanor had been influenced by a caretaker whose own psychological state was not fully reliable. Anna looked at him without changing her expression. "Let them try," she said. Victor Hale almost smiled. It was the first and only flicker of something warmer than professional attention. "Good," he said. "Then let's get to work." She spent the next 3 months building the case the way she had been trained to build anything that mattered, from the ground up, without assumptions, without gaps. She drove to the oncology clinic on Paper Mill Drive and sat down with Dr. Gail Osborne, who had been Eleanor's oncologist for the duration of her illness. Dr. Osborne agreed to testify without being asked twice. Eleanor had tracked her own medication dosages throughout treatment, she said. She asked specific, informed questions at every appointment. She managed her own care actively until the final 2 weeks of her life. That is not the behavior of a woman whose judgment has been compromised. Anna went upstairs in Eleanor's building and knocked on the door of Nina Hartwell, 76, who had lived 2 doors down for 11 years and played cards with Eleanor every Thursday afternoon. Nina Hartwell was not a woman who softened things for the sake of comfort. "Eleanor was sharper than the 2 of us combined until the very end," she said. If her children believe otherwise, they are welcome to explain that position to me in a courtroom under oath. Anna visited the palliative care floor at the hospital and spoke with Katie, 27, the nurse who had been on Eleanor's case during the final weeks. Katie's voice was quiet, but her account was exact. 3 weeks before Eleanor died, she had dictated her own mailing address from memory without prompting, without hesitation. Full address, correct zip code. Anna wrote all of it down. Dates, direct quotes, the specific details that turn testimony from impression into record. She built a written chronology that ran to 14 pages by the time she was finished. 12 years of intelligence work teaches you above almost everything else that the difference between a strong case and a weak one is almost never the facts themselves. It is whether someone took the time to document them properly. She had spent over a decade being trained to gather evidence under pressure in conditions considerably less comfortable than a Knoxville law office. Nobody in that family knew they were about to find out what that actually looks like. By January, Victor Hale had reviewed the full file and scheduled the first hearing. Knox County Chancery Court, February. The first hearing was on a Tuesday morning in February. Knox County Chancery Court sits on Main Street in downtown Knoxville, a building that carries the specific weight of a place where consequential things are decided, and everyone inside understands that. Anna arrived 20 minutes early in dark slacks, a gray blazer, and her hair pulled back. Victor Hale was waiting at the entrance with his briefcase already open, reviewing something. He closed it when he saw her, and they went in together. Robert, Linda, and Dana were already in the corridor outside the courtroom. Dana was in a long camel coat that had not been purchased on a Nashville agent's starter salary. Dennis Carver stood with them, 38, and composed, going over a document with the unhurried confidence of someone who considers this hearing a formality. Robert saw Anna come in and looked at her once, brief, flat, the way you look at something that is in your way. Linda did not look at her at all. Dana glanced over and lifted the corner of her mouth barely. It was not a smile. It was the expression of someone marking your presence on a list. Inside the courtroom, Judge Patricia Wynn, 55, presided with the economy of a judge who has been through enough hearings to know which details matter and which ones are performance. Dennis Carver presented the plaintiff's case cleanly and without excess. Eleanor Merritt had been in the advanced stages of terminal illness at the time the will was executed. Palliative care, significant pain management, the physical and cognitive toll of stage 4 cancer. None of these, he argued, were conditions under which a person could be said to have exercised sound legal judgment. The will should be voided. The condo should pass to all eligible heirs under Tennessee interstate succession law, distributed equally among Eleanor's surviving children. He made it sound like the obvious and merciful resolution to an unfortunate situation. Victor Hale responded without raising his voice. A terminal diagnosis, he said, does not establish testamentary incapacity under Tennessee law. The will had been formally executed before a notary who had recorded Eleanor's competency at the time of signing. The medical record did not support a claim of cognitive decline during the relevant period. The defense had witnesses prepared to testify on exactly that point and was requesting they be heard at the next proceeding. Judge Wynn scheduled the second hearing for 3 weeks out and adjourned. In the corridor, while Victor was at the clerk's window, Dana crossed the hall toward Anna with the purposeful walk of someone who has planned this moment. She stopped close and kept her voice low. "Take a third," she said. "We all walk away from this clean." Anna looked at her. Walking away clean would have meant not filing the lawsuit in the first place, she said. Something moved across Dana's face, not hurt, just the brief tightening of someone who had expected a different answer and was recalibrating. "You were always like this," Dana said. "You act like serving made you different from the rest of us." Anna did not answer that. There was not an answer worth giving. Dana held her gaze for a moment, then turned and walked back to where Robert and Linda were waiting by the elevator. 3 weeks later, Anna's phone rang from a number she did not recognize. The call came on a Wednesday midway through the week between the first and second hearings. The voice on the other end was male, older, unhurried in a way that suggested someone who had spent a long career choosing words carefully and never entirely lost the habit. He introduced himself as Peter Voss. He said he had known Eleanor Merritt since 1963. He said he had something that belonged to Anna and that it was relevant to the case. He asked if she would meet him the following morning. They met at a coffee shop on Market Street, a few blocks from the courthouse. Peter Voss was 70 years old, trim and deliberate, with a posture that came from decades of sitting across desks from people and paying attention. He had been a notary public for 31 years before retiring 5 years ago. He and Eleanor had met as students at the University of Tennessee, stayed in contact through marriages and moves and the long ordinary passage of time, and had remained genuine friends for over 60 years. He ordered coffee and did not make small talk. He reached into the bag he had brought and placed a manila folder on the table between them. Eleanor had given it to him 8 months earlier, he said. Her instructions were clear: hold on to this, and if there is ever a court case over the estate, give it to Anna. He had watched the obituary, waited to see what the family would do, and when Natalie Rhodes confirmed that a contest had been filed, he made the call. Anna opened the folder. Inside was a handwritten letter, 3 pages in Eleanor's unmistakable script, the same angular, deliberate handwriting Anna had seen on birthday cards and grocery lists, and the recipe for apple cake that was still taped inside a kitchen cabinet upstairs. The letter was dated 11 months ago, 4 months before Eleanor died and 2 months before she executed the will. It was addressed simply to a court, no case number, no specific jurisdiction, just to the court that may hear this matter. It was not an emotional document. Eleanor had not written it to be moving. She had written it the way she apparently did everything, with the intention of being exactly clear. 3 pages of names, dates, and specific episodes. Who had visited and when. Who called regularly and who called once a month out of what read, even in plain recounting-like obligation. Who had not called at all during the final summer. The record was precise and unsparing and entirely without self-pity. The final lines read, my granddaughter Anna gave up her career to be with me. The others gave me up for their convenience. It is my right to recognize that correctly. Anna read it once, then read it again. Then she folded it along its original creases, closed the folder, and looked at Peter Voss. She knew, Anna said. She knew exactly what they would do. He nodded. Eleanor never did anything without thinking it through completely, he said. She told me when she gave me that folder that she expected the will to be challenged. She was not bitter about it. She was just prepared. He paused. She also said, if it comes to court, Anna will know what to do with it. Anna sat with that for a moment, the image of Eleanor in the chair by the window watching the street below with that particular stillness. And understanding now that the stillness was not only peace. It was also calculation. She had been building a case while she was dying. She had thought past her own death to what would happen afterward, and she had left a document in the hands of a trusted friend with instructions precise enough to function without her. Eleanor was dying, and she was still thinking 2 moves ahead. She did not leave Anna a letter of comfort. She left her a weapon. That afternoon, Anna drove to Victor Hale's office on Gay Street and put the folder on his desk. He read the letter without interrupting himself, without setting it down, without looking up. When he finished, he was quiet for longer than Anna had seen him be quiet before. Then, he said, this changes the shape of the case. A written statement prepared in advance, addressed to a court, containing specific factual content, and a direct anticipation of legal challenge. Tennessee Chancery courts treat that as serious evidence bearing on testamentary capacity. Combined with what we already have from Dr. Osborne and the others, this is a substantially different case than it was this morning. He looked up. Your grandmother was a careful woman. She was smarter than all of us, Anna said. They agreed on timing. The letter would not be filed in advance, would not be referenced at the first hearing, would not be mentioned in any pre-hearing communication. It would come out at the second hearing. At the moment, Dennis Carver and his clients believed the momentum was theirs. The second hearing was 3 weeks after the first. Same courtroom, same institutional light, same long table with the plaintiffs on one side and Anna and Victor Hale on the other. Dennis Carver opened for the plaintiffs, and he was good at it. He built the argument methodically: Eleanor's physical condition in the months before her death, the palliative care regimen, the medications, the cumulative toll of terminal illness on a 78-year-old woman's capacity for sound legal judgment. He did not overreach. He kept his language measured and his tone appropriately somber, the tone of someone presenting an unfortunate truth rather than making an accusation. The room had the quality of moving in his direction the way rooms do when the first voice sounds certain and no one has yet said otherwise. Victor Hale called Dr. Gail Osborne first. She took the stand with the composure of someone who has delivered difficult information in formal settings for 20 years and does not confuse composure with detachment. She was precise and direct. Eleanor Merritt had tracked her own medication dosages throughout her treatment. She had asked informed, specific questions at every appointment. She had demonstrated consistent cognitive clarity through the final weeks of her life, which in Dr. Osborne's clinical experience was not the profile of a patient whose judgment had been compromised. She said it without editorializing and sat back down. Victor called Nina Hartwell. Nina Hartwell was 76 years old and had no interest in performing for anyone in that room. She said what she knew. Eleanor recited poetry from memory, Frost she thought, and some Dickinson. Eleanor knew her full medication schedule without being reminded. Eleanor had on at least 3 occasions re-explained the rules of gin rummy to Nina because Nina kept misremembering one particular rule about knocking. Nina said that is not a woman who did not understand what she was putting her name to. She said it the way people say things they consider self-evident and sat back down. Something in the room had shifted. Not dramatically, not with any single visible moment. But Carver's composure, which had been seamless coming in now, had something working against it just beneath the surface. Then Victor Hale stood and told the court that the defense had an additional document to enter. A written statement, he said, prepared by Eleanor Merritt in advance of the will's execution, addressed to a court, in which she had documented her own reasoning and her anticipation that her decision would be challenged. Anna walked to the bench and placed the folder in front of Judge Wynne. The judge opened it and began to read. The courtroom went quiet. Not the ordinary quiet of a proceeding between speakers. Something different, the quiet that settles when the people in a room collectively understand that what is occurring in front of them matters and that the right response is to be still. Dana broke it. What is that, she said loud enough that there was no pretending it had not been said. What did she just hand up there? And then, the thing that had apparently been building since the first hearing, or perhaps much longer than that. Who does she think she is, some deadbeat who could not even keep a real job? Judge Wynne looked up from the letter. She looked at Dana with the unhurried steadiness of someone who has presided over enough hearings to know exactly what this moment is and exactly what it requires. She told the bailiff to secure the courtroom doors. No one was leaving. She addressed Dana directly, and without visible emotion. The remark had been made on the record. It constituted contempt of court, and it would be treated accordingly. One more incident of that nature and Dana would be removed from the courtroom and fined under Tennessee rules of civil procedure. Was that understood? Dana opened her mouth, then closed it. She nodded, a small and involuntary motion, the nod of someone who has just been publicly placed somewhere they have never been placed before. Dennis Carver wrote something on a notepad and slid it across the table to her. She read it, put her hands in her lap, and did not move again. Robert had turned toward the wall at some point during Dana's outburst. He stayed that way. Linda sat very still. She had been a certain size when the hearing started. She seemed smaller now. Judge Wynne returned to the letter and finished reading it. Then she addressed the document formally. For the record, it had been composed 2 months prior to the will's execution and 4 months prior to the testator's death. It was addressed to a court. It contained specific names, dates, and documented circumstances, and it included an explicit statement of reasoning and a clear anticipation of legal challenge. The court was ordering a forensic handwriting examination to establish authenticity. The document was entered into evidence. Hearing adjourned. In the corridor, while the room was still clearing, Dennis Carver approached Victor Hale. He kept his voice low. He said the letter had not been something his preparation had accounted for. He said his clients might be willing to discuss a settlement if Anna's side was open to the conversation. Victor said he would consult with his client and be in touch. When Carver walked away, Anna looked at Victor. "Is that good?" she asked. Victor closed his briefcase with the same unhurried precision he brought to everything. "It means they can see where this is heading," he said, "and they want to get out with the least damage possible. When the other side offers to settle after the second hearing, that is not a gesture of goodwill. That is math." He picked up the briefcase. "Now we wait on the handwriting report." Anna drove back to 4th and Gill the evening of the second hearing and did not go out again for several days. The forensic examination would take weeks. There was nothing to do but wait, work, and stay in the condo, which she had been doing anyway and intended to keep doing regardless of how long the process ran. The routines she had settled into over the past months held. She made coffee each morning in the old percolator on the counter. The aluminum one with the dented base that Eleanor had owned for at least 20 years and refused to replace on the grounds that the coffee tasted better from it. She worked at the kitchen table during the day. The risk assessment consulting work that translated her Army background into something that paid reliably and required no explanation of which units she had served in. In the evenings she read from Eleanor's shelves. She had not moved a single bookmark. Whatever page Eleanor had left a book open to, that was where the book stayed. Anna read around those pages or read up to them and stopped, and she did not examine that habit too closely. Linda called on a Thursday evening about a week after the hearing. Anna was in the chair by the window when the phone rang. She recognized the number and let one ring pass before she answered. Linda's voice was different. The controlled pressure that had characterized her calls over the past months, guilt 1 week, legal consequences the next. The occasional suggestion that a negotiated settlement was really the mature resolution was gone. She sounded tired in the straightforward way, the way people sound when they have been pushing against something for a long time and have just let their hands drop. She asked how Eleanor had been at the end. Whether Anna had been with her. Anna told her. Eleanor had been calm in a way that did not feel performed. She had asked for stories, the funnier the better, and Anna had gone out of her way to find things worth telling because Eleanor laughed at the absurd ones and it was worth the effort. She read until the final 2 weeks. She did the crossword in the morning and complained with genuine irritation that the news had gotten worse across the board. 2 days before she died, she asked Anna to open the window because she wanted to hear the street. They sat together in the quiet and listened to children playing in the courtyard below. Eleanor had closed her eyes. She was smiling. That was what the end looked like. The line was silent for a moment. Then Anna said, without any particular force behind it, just as a thing that was true, "You did not come. None of you." She was not saying it to cause pain. She was saying it because it was accurate and because she had stopped seeing the point in treating accurate things as if they were too fragile to name. Linda did not respond to that directly. Anna told her she was not carrying anger toward her and meant it. But the condo was not something she was willing to negotiate, not for money and not for the sake of keeping the peace. Because Eleanor had made that decision with complete awareness of what she was doing. She had written a letter to a court about it while she was still alive. The least Anna could do was honor it. Linda put the phone down quietly. No argument. No final word. Just the call ending. The following week, Robert called. His voice had none of the transactional steadiness from the first conversation, the one where he had laid out the lawsuit like a contractor explaining a bid. This was slower and heavier, the voice of someone who has not been sleeping well and has stopped pretending otherwise. He told her Dennis Carver had advised them that the case was effectively over. Once the handwriting report came back, there would be no remaining argument to make. He said Linda had been right from the beginning. They should have come to Knoxville. He said the lawsuit had been wrong. Not just strategically wrong, he said. Wrong before any of that. Anna listened to all of it. When he finished, she told him she heard him. She told him she could not give him what he might be hoping for, not yet, it was too soon, and she needed time with it. The condo was staying with her, that was not a point she was willing to revisit. But she had heard him. He said okay. Just that one word. Then he hung up. Robert Merritt called his daughter to tell her he had been wrong. That takes something. It does not undo anything that happened. But it takes something. And it would be dishonest to say otherwise. 25 days after the second hearing, Victor Hale called at 8 in the morning. Anna was in the chair by the window with her coffee, watching snow come down over the 4th and Gill rooftops, the first real snow of the season. The kind that settles quietly and makes the neighborhood look briefly unfamiliar. She picked up on the first ring. The forensic document examiner was a woman named Dr. Sandra Cook, 30 years in the field, court certified, the kind of expert whose written conclusions judges read carefully and opposing counsel does not challenge lightly. Her report ran to 9 pages. 18 of 20 standard identification markers confirmed a match. The conclusion was stated without qualification. The letter had been written by Eleanor Merritt. No alternative authorship was consistent with the evidence. Victor read her the key finding over the phone in full, then said both sides received the report simultaneously, standard procedure. He expected to hear from Carver before noon. Carver called at 9:45. The plaintiffs would withdraw the contest. No conditions attached, they would cover their own legal costs. Anna would cover hers and the claim would be dismissed. Victor told him he would confirm with his client. He called Anna back 2 minutes later. She told him clean withdrawal, nothing in the language that leaves any ambiguity in the record, nothing that could be reopened or reframed later. Victor relayed this. Carver agreed. 3 weeks later, the third hearing was scheduled for a Monday morning in December. That put roughly 6 weeks between the forensic results and the formal closure, enough time for Carver to file the withdrawal paperwork for the court to schedule the docket, and for everyone to prepare for what was by then a proceeding with only one possible outcome. December in Knoxville was cold and gray, and arrived early that year. Anna got to the courthouse 40 minutes before the hearing and sat in the corridor outside the courtroom, listening to the building settle around her, the distant sound of doors, the low conversation from the clerk's office down the hall, the particular stillness that old public buildings have on winter mornings. She had sat in a lot of waiting rooms over 12 years. This one felt different. This one was almost over. Robert, Linda, and Dana arrived together and took up a position against the wall on the far side of the corridor without speaking to each other or to anyone else. Dennis Carver came in a few minutes later and spoke to them briefly in a low voice. Dana was looking at the floor. Robert nodded at something Carver said. Linda was standing a half step apart from the other two, not dramatically, just enough to notice if you were paying attention. Anna noticed. Victor Hale arrived, set his briefcase down beside Anna, and asked if she was ready. She was. Inside, Judge Wynne read the forensic findings into the record methodically and without comment. 18 of 20 markers confirmed. Conclusion unqualified. She looked at the plaintiff's table. Dennis Carver stood. He spoke in the flat professional register of someone executing a necessary step correctly and without self-pity. On behalf of all plaintiffs, he said the contest was being withdrawn in full. He asked the court to dismiss the proceeding. Judge Wynne noted the withdrawal for the record and closed the case. Then she did something that Victor Hale told Anna afterward was genuinely uncommon. She set down her pen and addressed the courtroom directly outside the formal record of the proceeding. She said the written statement that had been entered into evidence in this matter was a document of uncommon clarity. The person who wrote it had understood her own actions, their consequences, and the specific objections that would be raised against them, and had addressed all three with full and deliberate awareness. This was unambiguously established by the content of the document itself. She said this plainly without ceremony, and then closed the hearing. Eleanor never got to hear that. She never sat in that room and heard a judge describe her letter as a document of uncommon clarity. But she had written it knowing exactly what it needed to say and exactly what it needed to withstand. She had been right about all of it. She knew. In the corridor, Victor Hale shook Anna's hand the moment they were clear of the doors, not the professional courtesy handshake of someone closing a transaction, but the kind that means something. He told her it had been done cleanly and correctly. Anna said that was Eleanor's work, not theirs. Victor shook his head. Eleanor gave us the document, he said. You carried it through 3 hearings without dropping it. Both of those things matter equally. Robert and Linda were already moving. They walked toward the exit at the end of the corridor without slowing, without speaking to each other or to anyone else. Heads down, in the manner of people who want to be somewhere other than where they are. At the door, Linda stopped. It lasted only a moment. She turned and looked back across the corridor at Anna, the full length of the hallway between them. No words. No gesture. Just the look, and then she lowered her head and pushed through the door after Robert. It was the most honest thing Linda had done in the 9 months since Eleanor died. Dana came out last. She walked the way she had walked into every hearing, coat buttoned head level, moving through the space as if she had considered and accepted her right to be in it. She was almost to the stairwell when she stopped. She turned around. She looked at Anna directly, and the thing that had been consistent throughout every corridor conversation and every courtroom glance that practiced evaluating surface. The expression of someone who always knows in advance how things will go was gone. She just looked. You won, she said. No bitterness in it. No concession either. A statement of fact delivered the way Dana delivered most things, as if emotion were a separate matter from accuracy. Eleanor won, Anna said. I brought the document. Something crossed Dana's face at that, too fast to name, gone before it fully formed. She nodded once, the nod of someone who has nothing left to add and knows it, and walked into the stairwell. Her heels on the stone floor, steady and even. Then the sound stopped. Then the heavy door swung shut. That evening Anna called Natalie from the chair by the window. Natalie picked up on the first ring. She already knew Victor had sent a brief message through a mutual contact, but she said, "Tell me anyway." So Anna told her. When she finished, Natalie was quiet for a moment. Then she said, "I am really glad. I mean that not just as a thing to say." Anna told her she was too. She said she was tired in the specific way you get tired after something that required everything and turned out to be worth it. Natalie laughed, warm and familiar, the laugh Anna had known since they were both 22 and trying to get through the same training course. That is the right kind of tired, Natalie said. In the weeks that followed, the family settled into its separate silences. Linda sent a text one afternoon with no preamble, "I am sorry. If you can forgive me." Anna sat with it for several days before writing back, "Not yet. But I am working on it." Linda did not reply, and Anna had not expected her to. It was not the message that needed an answer. It was the message that needed to be sent. Robert did not call or write. Anna did not spend time trying to move something she had no leverage on. 12 years of service had made that particular discipline automatic. Dana said nothing. Anna found she could respect that more than she might have expected. Silence when there is genuinely nothing to say is at least honest. It does not pretend. 6 months later, it was April, and the light through the tall windows in the late afternoon had turned the pale gold that only happens in spring before the leaves are fully out. Anna was in the chair by the window with one of Eleanor's books open on her lap. The bookmark was still where Eleanor had left it. She had read up to that page and stopped. From the courtyard below, someone was laughing, distant and easy, belonging to a day that had nothing to do with any of this. Anna closed the book and sat with the quiet for a while. Not the quiet of waiting for something to go wrong. Not the quiet of a pause before the next thing. Just the condo and the light and the faint sound of the street coming through the window she had left open an inch, and the books on the shelves with Eleanor's handwriting in the margins. She came back sometimes in moments like this to the last line of Eleanor's letter. Eleanor had written that Anna sacrificed her career to be with her. Anna had turned that word over many times in the months since she first read it, and she had decided with some certainty that it was the wrong word. She had not sacrificed anything. She had made a choice, and both parts of that choice, the army and what came after it, had been fully and completely hers. Sacrifice implies the loss stays a loss. This one did not. She had been in the room. She had heard the children playing in the courtyard below. She had watched Eleanor close her eyes on the last bright morning with the window open and something that looked like contentment on her face. That moment does not appear in any legal filing. It cannot be contested, examined, or overturned. It simply happened, and it belongs to Anna, and there is no court that can touch it. Eleanor prepared for that courtroom fight while she was still alive because she knew her own family well enough not to trust them with her last decision. If you have ever watched someone you love leave behind a family like that, tell us in the comments. Did they get it right in the end?